Thank you for your patience. We're here today in our case Wednesday CV 180651 JST et al. Versus Daisy Mtn et al. Each side will have 20 minutes to present their argument. Appellant, you may save any time that you wish for rebuttal, but it is up to you to keep track of your own time on that. That's why we have a clock at the podium. We are recording the argument today, both audio and video, and I believe we're also live streaming. So when you come forward, please identify yourself and your client so that we can keep everything straight when we review the audio or the video. And the argument should be on YouTube in a day or two. We have read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the facts and the argument. So for both counsel, when you begin your argument, just start out with the points that you would like for us to consider. Counsel, you may begin.
Yes, Good morning. May it please the court, my name is Christina Reeves and I represent the appellant JST Enterprises et al. I will be presenting argument for 12 minutes and I intend to reserve 3 minutes of my time for rebuttal. My colleague, Mr. Seaver, who represents CNS Towing, will use 5 minutes of appellant's time to present those arguments with which JST does not agree.
And no, that's up to you to keep track of that.
Yes, Your Honor. So my goal is to sit down when I have 8 minutes left, and I will try to do that. Your Honors, in asking this court to reverse the trial court's grant of the motion to dismiss, we are not asking this court to break any new ground or establish any new law. We are simply asking this court to reaffirm the law as it has been in Arizona for the last over 30 years. But firefighters are asking this court to erect a sea change in Arizona's negligence law by granting them absolute immunity when they have never had that kind of immunity before.
Counsel, if I may ask, I understand from your briefing that the basis of the duty that you're proposing is the statements that were made to your clients. If those statements had not been made, would you be here today?
No, there would not be a duty, Your Honor. If those the statements that the firefighters made to the property owners or their representatives is what created the duty under Section 323 of the Second Restatement of Torts. If those statements had not been made, then as alleged in the pleadings, the property owners would not have left their property. They would have stayed on the property and undertaken their own efforts to protect their property. And no, we would not be here because we wouldn't have a claim against the firefighters.
But would that be because there would not be a specific duty between the fire department to your clients without those statements?
Yes, that is our position, is that without those statements, there would not have been a duty. But because
and that's regardless whether your client stayed or didn't stay, correct?
That is regardless of whether our client stayed or didn't stay. The duty was created by the firefighters making those assurances to the property owners or their representatives that they would leave fire spotters on the property throughout the night to watch the property in case the fire rekindled.
So, counsel, you started off on absolute immunity, but that's not really the question. It's duty, right? Or did I miss something?
The question here is liability. And when we're talking about government actors, we need both duty and we need to overcome qualified immunity.
Right.
So we have to consider both.
Right. Qualified and absolute immunity will come in play down later in the litigation, it's almost a hurdle you need to overcome with the bad act. But if we're just talking about duty, let's focus on that. Do you have any Arizona case law that applies 323 to firefighters in this, or just firefighters? To find a duty, negligence, damage to the property, applying 323 in Arizona?
I do not have any cases that I can cite in Arizona where there was a duty by firefighters under these circumstances under 323. So no, there is no case with these similar circumstances where that kind of duty was created under restatement of tort section 323. There are lots of case law discussing section 323, the negligence undertaking, since that's been the law in Arizona, but none that specifically address this situation with firefighters.
So we'd have to expand the law, at least today, to accept your argument.
No, we wouldn't have to expand the law at all. The law in Arizona is that government actors have a duty that's coextensive with other citizens. They have that same duty. And the law in Arizona is that when a person undertakes to render a service to another, they have a duty not to perform that service negligently. That is the law. There is no need to expand the law or change the law. It just reaffirmed the law as it is.
So when you say a duty to undertake, that's 323.
Not a duty to undertake. I meant when they undertake to render a service. Yes, they have a duty to not be negligent in that undertaking.
Let's put 323 aside. Do you need 323 to prevail, or is there this other duty that you referred to, long-standing, that Arizona public?
That is the duty that I'm referring to. I do need 323 because a duty is defined as an obligation recognized by law. So I need an obligation recognized by law. And since Arizona recognizes section 323, there's the law that creates the duty that we're saying applies here.
But never for firefighters, at least yet.
There's never been in a case that applied it to firefighters, but there's also never been a case where they found that there was an exception for firefighters. All of the case law in Arizona is that government actors owe the same duties under the same circumstances that private citizens would owe under those circumstances. That's the law in Arizona, and there's never been an exception for firefighters or police officers or parole officers or any other kind of first responders. And in fact, in Chamberlain v. Mathis, the court discussed whether or not it should get rid of the duty when it comes to police officers. In Portanova v. Wilkinson, it discussed that case where the police officers asked for the duty that applies to every other citizens to not apply to them, and the court said no.
Let's look at the facts of this case. For the firefighters here to have avoided liability, they would have had to say, yeah, grab your hoses and let's fight this. Is that accurate?
For the firefighters here to have avoided liability, they would have had to not made the affirmative statements to undertake to render a service to the property owners, and they had to have not acted in reckless disregard of the property owner's rights. Because again, liability, we have to have that duty, and we have to overcome qualified immunity.
So counsel, if the fire department responded to the fire, made no statements, but didn't competently fight the fire, there would be no lawsuit on your behalf.
No, that is accurate, and the court said that there is no duty when firefighters undertake to engage in firefighting efforts, because they're not rendering a service to a particular property owner, they're rendering a service to the state and the community at large.
Right.
That would be accurate, and that's not what we're claiming.
It's the interaction that you're pointing to.
Yes, Your Honor.
And that interaction was, we want to help you, we want to fight it, and they were told, we got this under control, we'll have fire spotters, go on your way, and that's the duty.
Yes, Your Honor.
Okay, so now let's explore that.
Yes, Your Honor.
Let's say you have an announcement, a broadcast that goes to thousands of people that says, evacuate the area, don't worry, we have it under control. Is that a duty to everyone who has an ear?
No, Your Honor, and again, that's ACRI. In ACRI, the plaintiffs brought a claim because they alleged that the evacuation order, there was negligence in the evacuation order, and this court found that that did not create a duty because the evacuation order was to benefit the community at large and not any particular property owner. Here we have that specific interaction between the firefighters and the property owners where they undertook to render service to these particular property owners. They didn't say that we're going to fight the fire at large, we're going to fight the fire wherever it may lead us. They said, we are going to leave fire spotters on your property to protect your property throughout the night. That was undertaking to render service to those property owners.
So let's say the firefighters say, yeah, you can help us out. And God forbid, your client is harmed, is injured. Is the firefighter or fire company responsible for any wrongful death claim?
That would be a very fact-specific question and the harm, but
I mean,
it's
we're talking
not
about fire, and I would think if you ask the fire company why they tell people to leave, it's for safety reasons.
And if this wasn't granted at the motion to dismiss stage, and we were able to conduct discovery and have more information about whether or not the firefighters told them to leave because there was a danger, then we would be able to see if this case fits in that box. But because this is a motion to dismiss, we're looking at the allegations. And the allegations in the complaint are, they told me they would leave fire spotters. I relied on that and didn't undertake my own efforts to protect the property, and I suffered a harm from that. That's the allegations.
So you can see that it may be down the road that you're not able to prove what you need to prove really as far as duty, but that's not what we're dealing with here today.
Yes, Your Honor, I cannot predict how the discovery is going to come out. Obviously, my hope is that it'll come out to benefit my client, but I can't predict how that's going to go. But because this is a motion to dismiss, we don't know the answers to those questions. All we have is the allegations.
Turns on. Go ahead.
I was just going to say, counsel, don't we get into a lot of factual dissection of what firefighters can say at the scene? I mean, if they, what here creates the duty? Is it, can they say, we're fighting fire, it's under control, we're going to leave fire spotters? Does that create a duty, or does it have to go one step further and say, we're going to leave fire spotters on your property? Does that suddenly change the analysis?
I'm sorry.
Because here's the reality is firefighters are going to talk all the time, and at the scene, if they're asked a question, how's it going, and they say it's under control, does that create a duty?
If they just say it's under control, I don't think that would create a duty. And we're not asking the firefighters we're not asking much of the firefighters here to not have liability. All we're asking is, don't undertake to perform a service and then be negligent in performing that service. And if you're going to be negligent, at least don't be grossly negligent, because then you're going to be liable. And that's not an extremely high standard of what we want our firefighters to do. Just don't act in reckless disregard of others' rights. That's not much to ask from government actors. And I'd like to reserve the remainder of my time.
Dennis Seaver on behalf of Plaintiff Appellant CNS Towing LLC. I would just like to reiterate a couple of points that were made by counsel with respect to whether or not there's an Arizona case that specifically addresses the applicability of 323 to firefighters in Arizona. There is not. However,
or any case with duties a duty on a firefighter, even outside of 323, but go ahead.
No, I'm not aware of any specific case in that regard, but Acri clearly left the door open for this court to come in and make that final determination on whether or not 323 should apply. The court in Acri made a specific findings of fact when the plaintiffs in that case alleged that 323 should provide a specific duty of care to them, which the court then rejected. Going through the factual analysis in that case, the court basically said, look, there were no specific steps taken where we assured anybody that their properties were going to be specifically protected, which is completely different than what we have here. We have specific allegations by numerous people that the Daisy Mountain Fire Department people were telling them, not only do we have the fire under control, but more importantly, we're going to leave fire spotters there at the property just to look out for possible rekindles. And of course, when they didn't do that and we have a rekindle, we now have a significantly larger amount of damage. And we're not making a claim. My client had some initial damage during the initial part of the fire. We're not claiming any damage or any claim for damages in regard to that part of the fire. It's only after they are assured that there's going to be a fire spotter, A, that the duty then kicks in, and B, more importantly, that they then fail to actually leave the fire spotter, and we now have actual damages as a result of that, what I would consider to be reasonable reliance, but that's clearly a question for the jury to decide.
Is that dependent upon the representation that was made? Because in talking about 323, isn't it just the undertaking of the duty? So if the fire department had left fire spotters but pulled them out early and the fire rekindles, but they made no representation in the circumstances, would there still be a duty under 323?
Yeah, now you get back into the question of whether or not we have some type of immunity, because now the question of whether or not they're being pulled is a discretionary act by the fire department. My position in this particular issue is that once they tell everybody that they are going to leave fire spotters, that is no longer discretionary. Now they have to leave them, and the failure to leave them constitutes just regular negligence.
But counsel, at least I interpret Judge Rogers' question to be, if the statements were not made, if they responded to the fire and then left fire spotters there and then took them away in their judgment, would you still have a claim? And I think your counsel is conceding the answer would be no. Do you concede that also?
I don't, from the standpoint that once they make the representation that they're going to leave a fire
Yes,
spotter
but
there's a duty. Now the question becomes, how long does that duty extend? But that's a question of...
But if the statements had not been made, if the statements had not been made, in their own judgment they put fire spotters there and then took them out, would you still have a claim?
I believe we would, Your Honor.
So I think, so 323 says as follows: one who undertakes to render services. Where in there is there talk about this exchange and reliance, and isn't it one who undertakes to render services?
Yes, and when they make statements saying we are going to provide specific services for you, that implicates 323. And
where does it say that in 323?
Well, in counsel,
What?
I'm sorry, I was going to reserve the remainder of the time for counsel for her rebuttal. But
Okay.
counsel.
Good morning, Your Honor. My name is Reed Campbell, and I represent Daisy Mountain Fire Districts. A fire department does not owe a duty to protect private property from wildfire. This court should affirm the trial court's dismissal. As a matter of law, Daisy Mountain does not owe CNS Towing and JST Enterprises a duty of care to protect their property.
Counsel, it's my understanding when you're dealing with police the police, of course, have a general duty to protect the public, but they don't have a duty to protect any particular person of the public unless they specifically undertake the protection. Here, there seems, at the statistics, there are allegations that statements were made that might fit that mode. Do I misunderstand the law, or
Well,
how is this different?
Well, with regard to police officers, there's both an extensive common law history and a statutory history that has a duty to make an arrest, both in Arizona statutes and in common law under the Austin case and the Hodge case and the Hutchinson case. So what's different there is there's an actual detailed common law history specifically applying to police officers to investigate and make arrests. That corresponding duty is nowhere in the statutes regarding a firefighter's duty to fight a wildfire. In fact, the statutory framework for fire districts states what is a statutory obligation and what is a discretionary function. Fighting fires is under a discretionary function.
So are you saying there's never a duty for firefighters to discharge their responsibilities in some reasonable way?
Well, not to fight a fire. There's not a duty to fight a particular fire or to fight it in a particular way. And to the extent that there would be a duty, it wouldn't be owed to a particular person.
Do you have a case that says that?
A case that says what?
That there's never a duty for a firefighter to fight a fire competently or reasonably or in any other adjective?
Well, the cases that have drafted are in other jurisdictions.
So there's no Arizona?
There's no Arizona case that has addressed that issue specifically. The closest thing we have is the Acre case that said that a response to a wildfire does not create a duty to the Yarnell residents to fight it.
Well, I suppose that there is a duty to the general public for the fire department to competently fight a fire, but that doesn't attach to any particular person. Is that your position?
That would be my position, although I don't think that was addressed in the Acre court, which is the one that has addressed the duty owed to the particular residents. If I could just address one point that the appellants made, is they rely exclusively on 323. And following the Gibson case, restatements which have a foreseeability analysis can no longer be used to establish the duty. Instead, they can be used to establish what standard of conduct might be necessary to reach once that duty's been established. And this exact argument was addressed last year in front of the Supreme Court in the Alcoa case. In that case, they cited to a restatement involving a duty to maintain one's property, Section 331 and 371, excuse me, and that one said a possessor of land is subject to liability for physical harms to others when he should realize that they involve an unreasonable risk to harm. The court said that is essentially that it's foreseeable that his actions would harm him. The court.
So counsel,
yes.
Let's look at Judge Howe. The duty he raised with you. It's a general duty to society, everyone. Is that what you would agree with?
Well, I think it's a discretionary duty, and the general duty would be duties that are already recognized under common law. An example would be on responding to the fire, they can't run red lights or negligently operate their vehicle. When operating their equipment, they can't do it in a way that harms someone through negligence, when the common law has already recognized a duty to drive reasonably in response to emergencies.
Right. We're talking about negligent firefighting, okay? And so we have this dichotomy that we're talking about, a specific duty versus a general duty. And I thought you had agreed there was a general duty. Just said-
Within specific activities involved in that fire response. I don't think that there's a general duty to actually fight the fire, just the activities that may be involved in that, where there's a corresponding well-established common law duty, operating a vehicle, managing equipment, that kind of thing would render a general duty and potentially a specific one.
Counsel, let's go back. You referenced the Alcoa case.
Yes.
But in Alcoa, it specifically said that a special relationship could be created through 323, correct?
It said, it didn't say that a special relationship could be created through 323. Alcoa didn't address 323. It addressed a few different sections, but what it said was a pre-existing special relationship. And to give you an example of that, the Fry-Clark case out of Nevada made that same argument, or left open the possibility that a duty could be assumed, and it cited to a New York case called Florence v. Goldberg. That case involved the state of New York police department assuming a duty to provide cross guards to the New York City School District. And that was a decision that was made well before the events that led to the negligent conduct, a decision that could be made based on policy and decisions.
But Alcoa does, I know it doesn't discuss 323, but it actually references to 323 as an example of situations where there can be a special relationship formed by the undertaking, voluntary undertaking of the party, correct?
It does, and
Don't the 323 analysis is almost always going to involve some factual determination, isn't it, as to whether somebody actually did undertake that act?
yes, but what the court also said is that that is really an analysis that goes to breach and causation. And the courts made this point on page 569 and 570, if I could just briefly read to the court. It says, the amicus and the dissent also argue that Carver v. Salt River recognized a general duty owed to landowners for all off-premise injuries. Carver involved a plaintiff who was injured when a tree planted next to the public roadway fell on their car. They claim that the duty is based on 364, which provides off-duty conditions. Post-Gibson, 364 cannot be used as the basis for creating the far-reaching general duty proposed by amicus and the dissent. And we follow the restatements unless it conflicts with Arizona law.
So 323 could apply, but it can only apply if there's no factual dispute?
323 would apply if the duty has already been established. It would apply to potentially evaluate what that duty is and the extent. Example I would give is if the fire department entered into a contractual obligation to provide certain services and failed to do so. 323 could then be used to evaluate whether they breached the standard of conduct.
Counsel, so if, and I understand the actual facts are in dispute, but if someone from the fire department went to the property owners when there was a fire, or even and said, we will protect your property if there is a fire, would that satisfy 323?
No, it wouldn't, because there's no pre-existing duty between those parties. And it's a problematic analysis.
Well, but what? Well, let's assume there is not yet a fire.
Okay.
The fireman meets with the property owner and says, we will protect your specific property from a fire if there ever is one. Then there would be a duty.
I think it's a much stronger case for a duty because the fire department has the ability to evaluate potentially what it's given in return for that exchange bargain for.
Well, but I'm not talking about contract. If they want to assume that, I guess if they want to assume that duty, can they?
Well, yes, under this statute that gives them their powers and obligations, they have the right to enter into agreements or an assumption of a duty would be at least some sort of agreement to assume that obligation.
But once there's a fire, all bets are off as far as that goes. If there is a fire, the, according to your argument, the fire department cannot go to the property owner and say, we will protect your property.
Well, yes, that wouldn't be enough to assume a duty of care under the current law, especially after Gibson and Alcoa, because there's no pre-existing special relationship. And it's actually the reason Gibson removed that foreseeability element is because it creates this fact-specific driven analysis that the court, Arizona Supreme Court, was trying to avoid.
Well, but what foreseeability component is there to the question of assuming a duty or not? It doesn't matter whether anything is foreseeable. If the fire department assumes a duty, they assume the duty. What component of foreseeability is involved in that?
Well, the point of foreseeability is involved in 323, and that is what the plaintiffs are basing their claim on. That we should have known that by making statements to them that they would reasonably rely on those statements to their detriment. And following Gibson, saying that you look at duty before you analyze the fact-specific case, and following Gibson saying that foreseeability is no longer the analysis that we're going to use on whether a duty is owed, the restatement alone cannot create the duty. That would be evidence of, once duty is established, of breach or causation.
So let's look outside of Arizona.
Okay.
323, first of all, would you concede that Arizona has recognized 323 to create a duty? Not to any particular, but to create a duty. Would you go that far?
No, currently, no. After Gibson and Alcoa, any restatement that creates a duty based on foreseeability, 323, 371, another one referenced in that case is, I believe,
how is it?
Statement 364.
Judge Howe just asked you, but we got foreseeability here, and I know what you're talking about, the whole third restatement, and we're not big fans. And then we move to this test. One who undertakes to render services. That seems fairly current and primary, not forward thinking. What prevents, in this preference against foreseeability, recognition of those 6 words? One who undertakes to render services. Not in the future. Wait, you show up with your fire department and you start fighting a fire. What about that requires foreseeability?
Well, that's not what the restatement has more. It says one who undertakes gratuitously for consideration to render services for another, which he should recognize as necessary for the protection of the other. And your analysis, they're not here today arguing that it's based simply on undertaking services. Their argument is that specific statements made during this wildfire fight created the duty. So that's not an argument that is currently being made before this court.
So it has to be you show up for services and then which he should recognize as necessary for the protection. Okay, how is that requiring foreseeability?
Well, it involves the person who's making the undertaking foresee that the person who it's being rendered to is going to rely on it, and that reliance is will be foreseeable and will be the knowledge that they're going to rely on what's being said at that particular moment.
So that's foreseeability, is thinking someone's going to be relying upon what you're saying or not?
Well, it's foreseeing what action they will take following that is a reasonable action. So we're going to leave fire spotters based on the circumstances surrounding that. Is it foreseeable that they would leave their property? So that's a foreseeability analysis that Gibson v. Casey expressly rejected and that Alcoa affirmed last year in the Arizona Supreme Court.
So let's say Gibson v. Casey didn't exist.
Okay.
Would 323, would you have any problem with that, with us recognizing that as the law?
Yes, because for public policy concerns that I highlighted in my brief, is that just as public policy can create a duty, it could also, a court should evaluate public policy and refrain from creating a duty. And the Acre Court went into detail on the problems that would be created by recognizing a duty during a wildfire. It would disincentive.
But this is just a 12B motion, correct? I mean, we're just asking for permission to get into that courtroom door.
Yes.
So this isn't a clarion call from the roof that says firefighters are responsible or liable. It's just a question of whether they can take discovery.
Well, it's a question of whether there's a duty. And that's a question for the court and for the trial court and for you. And since that's a question of law, getting into discovery is unnecessary. And it's also problematic. And this case illustrates it perfectly because the firefighters here deny all of these statements. So are we going to, following every single fire, have these he said, she said arguments where fire departments get dragged into litigation for years based on what they believe the words were said during the heat of battle? That would raise the exact same concerns that the Acre Court was so concerned about. It would really render fire departments mute. They wouldn't give updates and community briefings for fear that it could create some corresponding duty. And that's not good public policy for Arizona.
Because I thought Acre didn't shut the door completely. That it said that there could be a special relationship out there that would allow the finding of a duty.
And that is true. And that could be an assumed duty via contract. The example that I think would be where they'd assume duty is, say they're fighting a wildfire and they go to a rancher and say, we'd like access to your lake. And the rancher says, I'll give you access to all the water you want, but in exchange for that, build me a fire break on my property line. They could assume that duty to build that fire break in exchange for that resource. But that would be a decision that would be made recognizing the benefits and loss of it, not some words of comfort or words of caution made in the heat of a battle during a wildfire. And then where does the duty end? CNS Towing and JST are saying that because these statements were made to its caretakers, the caretakers then relayed those statements to their bosses and property owner, that duty extends on down the line. It would just be unworkably broad. It would create potentially limitless liability, and fire departments would be reluctant to join the fight. And out-of-state fire departments would likely not come to Arizona's aid when we need them. Fear of doing so would create unknown tort liabilities.
Counsel, is there, based on your discussion of Gibson and Alcoa, is there ever a circumstance where duty determination involves factual issues?
I guess I don't quite understand your question.
Can there ever be a situation, and you rely on Gibson and Alcoa, and you don't want the court to get into these fact-specific determinations, but aren't there circumstances where there may be facts involved that have to be decided by a fact finder to find a duty?
Yes, for example, like a special relationship between a doctor and a patient, the fact that the doctor's the doctor and the patient's the patient, or potentially another pre-existing special relationship, or facts necessary to determine if there's a duty under Arizona common law.
Well, let's take that analogy with like an attorney. You have to look at whether there's been an attorney-client relationship formed, and that's based on discussions, representations that are made. Isn't this similar?
Well, the attorney-client relationship and the duties that stem from that they have a common law and statutory background. There's no matter what the analysis is between a citizen and a fire department, it doesn't end up in creating a special duty to them based on responding to a wildfire. And unless the court has any other questions, I see my time is up.
Thank you, Counsel. We appreciate your argument.
Thank you, Your Honors.
Counsel, if I might begin with the question, when we talk about 323 and undertaking to provide services, is your position that the undertaking to provide services was not showing up to the fire? It was making the representations that you alleged were made.
Yes, Your Honor, exactly. And just to point out, my friend from Daisy Mountain misreads Quiros and its findings of unforeseeability. In Quiros, the Arizona Supreme Court reaffirmed that in Arizona, duty is not created by foreseeability, but it can exist by virtue of special relationships and public policy. And as far as special relationships, it cited Section 323 as an example of where a duty exists by virtue of a special relationship that Arizona has adopted, and that is the law in Arizona. Section 323 is the law in Arizona, and it has been the law in Arizona for many, many, many years, and is applied to firefighters. This law has applied to firefighters, and firefighting efforts have continued unabated. So the idea that if this court reaffirms the existing law and says 323 still applies to firefighters, the idea that that's going to hinder firefighting efforts, there's absolutely no evidence to support that parade of horribles that Daisy Mountain has presented.
So you would concede, counsel, and I'm reading from ACRI, it says, we recognize that public policy considerations may militate against recognition of a duty.
Of course.
That's the law, right?
Yes.
Okay. So 323, you're saying, has been the law in Arizona. Okay.
Already has a recognition of duty.
But it's never been applied to firefighters.
Whether or not it's ever been, I can't say. I know that I don't have a case that says that it's been applied to firefighters.
Okay.
Maybe it was applied at a trial court. I don't know.
What cases, is it a grocery store that says you can walk down this aisle and someone slips and falls? And if it is, and I'd have to look at those cases, are we to consider the, not a great word, but obvious public policy differences that would muzzle a fireman or woman when they come to the scene of a fire versus, yeah, you can walk down aisle 3?
This court should not recognize a public policy exception to 323 applying to firemen. And I only have a few seconds, but in Quiros v. Alcoa, the Arizona Supreme Court said that courts should exercise extreme caution in declaring public policy, because the declaration of public policy is primarily the province of the legislature. And here, the legislature of Arizona has not. They've provided immunity and excused firefighters and other entities from applications of negligence law in Arizona, but they haven't done so here, and there's no reason this court should undertake to do so. And so we'd ask this court to reverse the trial court's grant of the motion to dismiss.
I appreciate your arguments, counsel, and we will take this matter under advisement and issue a decision in due course. We stand in recess until 1:30.